Hello everyone, welcome to Crystal Diaries. This is another video of the series of videos relating to law of contracts in India. And in this video, we are going to discuss a very important concept in contract, that is capacity to contract. In our previous videos, we have found that capacity to contract or competence of parties to contract plays a very important role in valid contract. So we are going to read about this, but before that, please bring your Bayrex with a notebook and a pen so that we can read the Bayrex simultaneously and we can note down all the important points whatever we discuss here. So let us begin. Now, Section 11 is the most important provision in the Contract Act so far as it relates to capacity to contract or competence of the parties to move into a contract. So, what does it say? It says, every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So section 11 says about three categories. First is the minor person, second person of unsound mind, and the third one is person disqualified by law. So these are the three categories of persons who cannot take part in a contract as party. So these people are not competent to move into a contract. So we are going to discuss these three categories one by one. So let us begin with the minor person. Now, who is a minor person? Now, Section 3 of the Indian Majority Act 1875 says, one who has completed the age of 18 years is a major. So whoever is below the age of 18 cannot move into a contract, or he or she is not a competent party to move into a contract. Now, there is another thing that we all should know, that when a court appoints a guardian for a person or the property, or for both the person or property under the Guardian and Wards Act 1890, then such person can move into the contract after he completes 21 years. Okay, so in normal case, when there is no guardian is appointed, so that person is governed by the Indian Majority Act, where he attains the age of 18 and then he is a competent party to move into a contract. But if a guardian is appointed for that person, then such person can move into a contract after he completes 21 years of age. Now, another important thing is that a minor can sue, but no one can sue the minor. Okay, so if one has moved into a contract with a minor fraudulently and that has resulted in some adverse situation for the minor, in that case the minor can sue. But if the minor, even though fraudulently, moves into a contract with another person, such other person cannot sue him. Now, for that we have to see a very important case, that is Mohari Bibi versus Dharmodash Ghosh. So let us know what happened in this case. So there was a boy named Dharmodash. He was a minor. So what happened? He mortgaged his house to Brahmodatta. Now Brahmodatta is a money lender, and Brahmodatta knew that Dharmodash was a minor. But despite knowing that he was a minor, he moved into a contract with him, mortgaged his house and gave him some amount of money. And after that, he asked for money, or he claimed that sum of money from Dharmodash. But mother of Dharmodash, she came into the front and she said that my boy, when he mortgaged the house, you knew that he was a minor. He was a minor then. So the contract is void. So you cannot claim any money from us. So for this, the minor brought an action against the money lender stating that he was a minor when the mortgage was executed by him, and therefore the mortgage was void and inoperative, and the same should be cancelled. And by the time of appeal to the Privy Council, the defendant Brahmodat died and the appeal was prosecuted by his wife, that is Mohri Bibi. Now the defendant said that the minor had fraudulently misrepresented his age. The law of estoppel should be applied against him. So therefore they should get the money. And also, if the mortgage is cancelled as requested by the minor should also be asked to refund the loan amount which he had taken. So the court held that the defendant contentions were not just. The minor's agreement was held void, and it was held that the minor could not be asked to pay the loan he had taken from him. So what it basically said, that the contract with the minor is void ab initio. That means that the contract is void from the very beginning. So you cannot sue any kind of money, you cannot ask for any kind of money or repayment. You knew that he was a minor then, so it was your fault that you gave money to him, you mortgaged his house, you shouldn't have done that. So in this case, you cannot sue a minor, nor can you ask him to repay back the money. Now let us understand about the second category of persons who are not competent to make contracts. So they are the persons who are of unsound mind. Now section 12 is the most important part dealing with this. So what does section 12 say? A person is said to be of unsound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and of forming a rational judgment as to its effect upon his interest. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. And a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of sound mind. So it is very much essential that the person should have a sane mind while he makes the contract. But if he is not, then he cannot make a valid contract. So now under this we are going to read about three different categories who fall under persons of unsound mind. The first one is idiot. So who is an idiot? Idiots are those persons who are devoid of thinking capacities. So they are unable to make rational judgments. So the contracts with such persons are void except for the necessities ones. Now the second category is lunatics. So you know that lunatics and idiots are mostly used in the same sense, but they are not so. A person is said to be a lunatic whose mental faculties are deranged. So these are the types of people who don't have lunatic periods for a continuous period of time, but it exists for a sporadic moment. It exists for a certain moment. The contracts with them are void except if it can be proved that it was entered when the person was having sound mind, or contracts made for his necessities, in which case his estate will be liable. Now the third category is drunkards. So a person who is under the impression of alcohol or drugs stands on the same footing as a lunatic person. Now the fact that a person was drunk affords no ground for resisting a suit for contract. But where the judgment of either party was affected because of the alcohol, then following the principles of equity, specific performance of the contract will be generally refused. So this is the case for voluntary drunkenness. In the case of involuntary drunkenness, then if the terms of the contract are disproportionate, then it can be set aside. Now let us move to the third category, that is a person disqualified by law. So this category of persons are also incompetent to move into contract. So under this we are going to learn about the alien enemy. So who is an alien enemy? He is a foreigner to the land whose sovereign is at war with our country. So an alien enemy is a person of another country, not of our country, but against that particular country there is war in our country. So in this case, we cannot move into a contract with the alien enemy. But as per section 83 of the CPC, no person shall enter into a contract with an alien during the subsistence of the war unless prior permission of the government has been sought. Now the next category is foreign sovereign. So in this case, you can enter into the contract, but you cannot sue that person, right? So again, if you read under section 86 of the CPC, you will find that the diplomatic staff of the government enjoys certain privileges in the aspect of contractual agreement. So it is stated that diplomatic people can enter into a contract, but with special privileges, which is they can sue the party for contractual failure, but they can't be sued unless special permission is sought by the government or they voluntarily submit themselves to the court. Now the third one is company or corporate. So in this case, companies include the local bodies and city corporation. These are the legal persons, and because of this, they can acquire property, transact their business, and are capable of suing and being sued. But they cannot do so without their seals as per section 21 of the Companies Act. Again, a contract entered by a statutory corporation is required to be within the object of the company. If it is outside the object, then it is ultra vires as per section 4 of the Companies Act. Now the next one is a convict. So in the case of convict, a convict also cannot move into a contract while undergoing imprisonment, and if he has to, then he has to take the permission of the central government. And the last one is an insolvent person. So an insolvent person also cannot enter into any contract. Why? Because his property is with an official assignee or receiver. So he doesn't have any property, he cannot be sued. So in this case, he cannot enter into any kind of contract. So these were the categories of people or persons who were incompetent to enter into a contract. So with this, we come to the end of our video. So till we bring a new video relating to law of contracts, please take care and keep practicing. Thank you and have a good day.